regarding this that could be transferred to Mumbai, it is for only that purpose that it was allowed. Like that the only purpose of a zero FIR? If you could just elaborate on it, I didn't get the concept.
Yeah, see, first information you have said under section 154, any
Right.
information with the police of you are required to give it to the police officer. So it's mandatory for the police officer to record the statement verbatim and transfer the FIR to the magistrate. See, the role of the police officer is quite limited. He will record it. Now, here in the case of Sushant Singh case, he dies in Mumbai. He dies in
Yes.
Mumbai. Whatever may be the allegations which are made is against persons who are residing in Mumbai, isn't it? Just because
Right.
complainant is residing in Bihar, and I don't think by any stretch of imagination such a complaint would lie in Bihar court. I don't think any of the provisions in Cr.P.C will enable the family members to prosecute. Of course, this is without prejudice to the rights and contention and the advice they may receive. This is my personal opinion. The Bombay courts alone have jurisdiction. Okay. Zero
Okay,
FIR
sir.
has no meaning. It has to be transferred. Its FIR should be under 154, where number will be given. A police officer will conduct investigation. He will maintain a case diary, report to the senior, report to the magistrate. Proceeding will go on. Isn't it?
Yes, sir.
But
Yes, sir.
now, why this matter went to Supreme Court? Because so many people lodged several complaints everywhere, all throughout India. Because the Bombay court
Right.
has jurisdiction to quash FIR only in respect of a case registered in Mumbai. It cannot register a FIR filed in Bihar or Uttar Pradesh, other places. That is why Supreme Court, SLP was filed, rightly so. And the Supreme Court under Article 142 of the Constitution has very wide powers to club all the FIRs together and send the matter to any court. Please do it. It's a liberty of the Supreme Court. Under section 406 and 407 of the Cr.P.C, Mansi, if you can open and read it, the Supreme Court and High Court have power to transfer any cases. This is a very relevant section. Please read section 406 Cr.P.C.
Thank you, sir.
पढ़ लीजिए आप. Isn't it? 406 में power of the Supreme Court to transfer cases and appeals. Isn't it? Only Supreme Court can transfer the various FIRs to one particular court. And cases cannot be tried in 10 courts or 2 courts, more than one court. You have to elect and select. Yes, the Supreme Court can decide, yes, for A reason, B reason. According to me, the place of trial, the matter should be referred to Delhi court or Punjab court or maybe Bihar court. Let them decide it. Such application should be filed under 406. And the Supreme Court has wide powers and under Article 136 as well as under the provisions of Article 142, preliminary powers of the Supreme Court. In order to meet the ends of justice, it can pass any orders. But the high courts do not have. High courts powers are limited under Article 226, 227. Within the state, they will pass the direction. Of course, a writ can be enforced even other matters, provided a writ is different. So, if you read section 406, why the Supreme Court came into picture, your doubts will be clear. Is that clear?
Yes, sir.
Yeah. Next. Can we proceed with the other question in there? Yes. Next is Z decided to stand for parliamentary election, but just before filing nomination papers under the Representation of People's Act, Z filed an appeal against the conviction in the High Court. Advise Z whether he can contest election. Of course, under the Representation of People's Act, he cannot convict, he cannot file I stand for election unless the conviction is set aside, isn't it? So here the question asked is, advise B whether he can. Number one, the High Court stays the sentence and pass the session, passed by the Sessions Court. B, the High Court stays the judgment passed by the Session Court. So merely staying judgment is not sufficient. The accused person has to obtain suspension of sentence under section 389 Cr.P.C. Please, Mansi, open 389. You got it here? Section 389 speaks of suspension of sentence pending the appeal. You got it?
Yes, sir.
You have to make an application. Then only, unless the sentence is suspended, that means your conviction, you will not be in a position to file it here. So your answer is C1. Okay. Then next is answer the following any of the four. Law relating to arrest in the case of female and judicial officer. Okay. Law relating to arrest in case of a female and judicial officer. Now, please see that here, the provisions of section 46 Cr.P.C. Section 46 provides for arrest of a woman. आप देखें what safeguards to be taken. They cannot touch the body of the women. Okay. Women arrested. A woman is arrested unless the circumstances indicate contrary. Submission to court. Oral intimation to be given to her first. Circumstances must be explained to her. A lady police officer must be there, and she cannot be touched on condition. Then no women can be arrested after sunset and before sunrise. Please note that here. A prior permission of the judicial magistrate is required in case you want to arrest on the time. That is subsection 3 and 4. Then this is women. Then what about the judicial officers? Arrest of a woman. Also, please see section 77 IPC, which deals with the acts of judges when sitting judicially. When it comes to women, section 77 check कीजिए आप IPC. Kindly open. मिला आपको section 77? Yeah. 77 says, act of a judge when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which in good faith believes good to be done by him. You cannot go and arrest a judge, a magistrate, when he or she is conducting proceedings or giving judgment or in the court premises. So section 77 gives one protection. Then another act is here. Please see that here. Judicial officers are also protected under the Judicial Officers Act, Judicial Officers Protection Act 1950 and Judges Inquiry Act 1968. Now there are guidelines laid down by the Supreme Court. You must be aware of a very famous case of Nadiyad magistrate case, where the judicial magistrate was handcuffed and paraded by the police officer in Nadiyad, Gujarat. Now, this case is reported in the judicial magistrates of Delhi. They filed a writ petition in the Supreme Court. That is, please see, Delhi Judicial Service and Association versus State of Gujarat, 1991, 4 SCC, page number 406. It's a very unfortunate case where a overzealous police commissioner, assistant commissioner, who had animosity with the judicial honest magistrate, invited him as a chief guest to the police station and wanted to teach a lesson because of his honesty and sincerity and uprightness. Make him consume drinks, alcohol drinks. He assaulted him and handcuffed and paraded in the entire Nadiyad place. This matter was highlighted and became a very serious issue, resulting in the Delhi judicial officers filing a writ petition in the Supreme Court. This is what the Supreme Court gave guideline number 1. Judicial officers should be arrested for any offense under limitation, under intimation to a district judge or the High Court as the case may be. Without intimating a district judge or a High Court judge, you cannot arrest a judicial magistrate or any judge. Number two, in case of necessity of immediate arrest, judicial officer, only a technical and formal arrest should be effected. You cannot handcuff him and take to police station. Just show in the record he is arrested and intimate and inform the High Court and inform the district judge. Number three, the fact of such a arrest, such immediate arrest of a judicial officer is only technical. Then the arrest should be immediately communicated to the district judge, session judge and the CJ of the High Court. District and session judge and the CJ, the chief judge of the High Court, should be informed that they are required to arrest this particular officer. Then next, the judicial officer so arrested should not be taken to police station without the prior order or direction from a district and session judge or the concerned district available. That is a mandatory now. You cannot take him to the police station without giving intimation of his arrest and that you would like to take him for interrogation to the police station. First, you are required to give intimation to the district judge. Then another requirement, no handcuffing of a judicial officer. Okay, then section 77 of the IPC, which deals with protection of judges of the act, good and good, it will be taken care. So this is your lengthy answer, and if it is for more marks, please bear in mind, if it's a short mark, you mention the Judicial Officer Protection Act 1950, 68 and Judges Inquiry Act 68 and section 77 IPC give immunity to judges in that regard, and directions are laid down, and you may cite the judgment of Nadiad Magistrate case, that is a Delhi Judicial Service Association versus State of Gujarat, 1991, 4 SCC, page number 406. Okay, next. Anybody has any doubt here? Yeah, next question is discuss in detail procedure of investigation. This we have discussed yesterday, we have discussed. There is no need to waste our time on this. Okay. Next is the classes of criminal courts and the territorial jurisdiction. Abhi discuss kiye humne. Read section 6 to 13 and 14 to 23. Abhi we have discussed it here. We will not again repeat it here. Then session trial. Session trial takes place from section 225 to 237 in chapter 18 CRPC. Please note that we have also discussed it. Then discuss the powers of the court to release certain offenders after admonition with reference to Probation of Offenders Act. That is section 3 and 4 of the Act nikal lijiye. Section 3 nikal lijiye. Yeah, section 3 says that here, people who are found guilty of offenses under 379, that is theft, under 380, theft in dwelling houses. Dwelling house ka punishment 7 years hai, 379 mein 3 years hai, 381 clerk and munshi or agent committing offenses is 10 years, 404 criminal dishonest misappropriation of money is 3 years, section 420, that is cheating. If a person is arrested, convicted under this offense, if it is a first offense, a person has no previous conviction, the judge or a magistrate may say that here, though he is found guilty and having regard to the circumstances and good character, he should be given the opportunity and the court will admonish him and let him off on Probation of Offenders Act. Okay, that is one reason. Then under section 4, more serious offenses, where persons who are convicted, not in death and imprisonment but life, barring death cases and imprisonment or life. Okay, another cases where the imprisonment may be below 10 years. Here having regard to the circumstances of the case, nature and character of a person, the court will release him under probation of a good conduct here. Under section 4, there is also provision under section 360 CRPC. There will be a probation officer appointed. Here the duration will be with 3 years time will be given here with assurities he will be on bond. That is the requirement of section 10. This is because our law is a reformative law. A person should not be facing jail term and become a criminal, especially young people, and they should be given let off here. So then subsection 2 says that here, the court will take into consideration the report of the probation officer who is appointed under section 4.2. So this all you have to write it here. Section 3 and 4, bear in mind with regard to this question. That is your answer. Okay. Then state how a child welfare committee is constituted under the Juvenile Justice Act. Section 27 is your answer. Here, the Child Welfare Committee is constituted under Section 27, which speaks of care, protection, treatment, redevelopment, rehabilitation of children in need and care, and protection of the basic needs and the protection. Okay. Then Section 30 deals with functions and responsibilities of the welfare committees, which include taking cognizance of and receiving children unproduced before it, conducting inquiries, issuing relating to safety with regard to the children. So here remember kijiye aap. Then direction given to welfare officer, probation officer. That is important. This question paper ends now here. The next question paper I will take it now today is 3rd December. 3rd December 2014. Okay. Let us go fast so we can quickly cover this. Then tomorrow the 2 papers I will cover them. Now the first question is inquiry or trial to be conducted in camera means. Section 372 check kariye aap CRPC. Camera proceedings. You know that, yeah? Camera normally under the CRPC, there is the open trial. Camera proceedings will start where an application is filed before the court. These are normally in cases of rape, cases of indecent representation, and wherever the women are concerned, where the rape cases are involved, outraging the modesty, adultery, all these cases, 327 CRPC may kindly be seen. We say that should be recorded in camera, including cases here. Now, there are lots of examples where camera proceedings have taken place. In Asharam Babu's case, the rape case against the religious leader, that is with a view to protect the witnesses. This is done with a view to protect the witnesses, which can be examined in the court. Then Leander Pace and Ria Pille's case, that is domestic violence case, they also made an application that camera proceedings maybe kindly take place here in the matter, because cross-examination taken place here. Then another case was a Tarun Tejpal's case, when application was made that the gentleman had raped his own colleague. The proceedings were held in camera. So please take into consideration section 327, camera proceeding. 327 says that the proceedings must be open trial, but there are exceptions. 327. Okay. The examples are given here. Normally the media is kept out, public gaze ke andar, not totally shut. They are camera trial. Yes. There are many cases which are now held these days in camera, but permission is required to be taken from the court in that regard. Okay. Now, next question will be define conviction and acquittal. So conviction and acquittal code में तो नहीं दिया गया, but I will give you the dictionary meaning. Yeah, conviction and acquittal, just take it down for you. Conviction means a formal detention by the verdict of a jury over the decision of a judge in a court of law that someone is guilty of criminal offense. Okay, this is the definition of conviction. And definition of acquittal, a judge, see the judgment or a verdict that a person is not guilty of the crime with which he has been charged with the trial resulted in a acquittal. Okay, this is the acquittal. That is the meaning. You have to give it here definition. Then oral complaint under the CPC, oral complaints, section 2D of the CRPC check कर लीजिए आप. Complaint also include oral complaints. Section 2, section 2D, complaint means any allegation made orally or in writing to the magistrate with a view to take his cognizance. So under section 190 CRPC, the magistrate has power to take cognizance directly. आपने पढ़े आपने. That provision you will find section 190. 190 के अंदर चेक कीजिए. Subclause A, upon receiving a complaint of fact we constitute the offense. It can also be oral complaint. Then upon a police report, then magistrate may empower magistrate of second class to take whole inquiry. So if an offense is committed before a magistrate, he will straight away say that a complaint is taken cognizance of. Yeah. Next is a summary trial. Now summary trial के लिए section 260 and 265 check कर लीजिए आप पढ़ चुके होंगे. 260 and 265. You know, summary trial is normally taken place. There is no substantial recording of evidence. Normally in cases of theft under 371, 380, 381, where the amount does not exceed 2,000 rupees, summary trial is taken place. Then where the amount is less than 2,000 up to 2,000. Then offenses under section 506 of the Indian Penal Code. 506 मालूम है, criminal intimidation, where the punishment does not exceed more than 2 years' time. It is there. Then abatement charges. Then Cattle Trespass Act, minor offenses. They're all tried summarily before a magistrate. Under the provisions of the summary trial, the magistrate cannot grant the sentence for more than 3 months. That is subsection 2 of section 262. Please note that here. These are summary trials. Charges mean, the definition of a charge is section 2B. Section 2, because you know the charges are framed under section 211 से लेकर अपने देखे हमने section 2B. Section 2B, charge includes a head of charges when charges contain more than head and one. Now the relevant provision with regard to charges are, you have seen that here, section 211 onwards. That is a chapter 17, 211 से लेकर 211. Yesterday we dealt with the example under 222 when charges is not framed so and so. 224 तक. 211 से लेकर 224, please remember the charges. Then admonition की meaning देख लीजिए आप. Admonition की meaning whether it is given admonition, section 4 में दिया होगा. What is a admonition? That is a Probation of Offenders Act में आएगा ये. Mansi, which is the provision in regard, can you just draw my attention? Whether admonition is defined under the Act. It's a warning given, no? Isn't it? Admonition
Not under
is taken down. Yeah, it is not given, but I got a dictionary meaning. Please take it and note it down. It's a reprimand from a judge to a person accused who has been found guilty of or who has pleaded guilty that he is not given imprisonment or fine but receives a lesser penalty in the form of a verbal warning due to minor infringement of the law. The conviction is still recorded. Admonition doesn't mean that you are discharged. Admonition doesn't mean that you are acquitted. You are convicted, but you are awarded lesser punishment. Isn't it? Like under the Probation of Offenders Act, the court may let you off giving you a warning. That is what section 3 says that here. Admonition, वहाँ पे use word किया गया. See that due to admonition, section 3 के अंदर. A good conduct, section 4 release him after admonition. One warning. Many magistrates in the cases now in this pandemic, many people have been roaming around without masks, isn't it? The police is filing charge sheet under the Epidemic Control Act, Disaster Management Act, under the IPC. The magistrates are just giving them penalty, imposing fine and admonishing कि दोबारा offense नहीं करने का. ये दोबारा करेंगे नहीं पहनेंगे तो आपको दोबारा double penalty मारेंगे. This is all happening here. So after admonition, the magistrate warns them here. Yeah. Next, define a children's home. That is, a children's home is defined where it is. Children establish and maintain. That is section 219 of the JJ Act. 219 check कर लीजिए आप. Is mean children home established and maintained in every district or a group of district by state government either by itself through a voluntary non-governmental organization and registered under section 50. This is for the protection of the children. Now in which case can a police officer arrest without warrant? Now वो सीखें आपने section 41 के अंदर example check करें आपने, isn't it? In all cognizable offences the police officer can arrest without a warrant. Lawful excuse, somebody committing offences under the act. So we have discussed this many times. I won't repeat it here. Please go through section 41 carefully. Now dispensing with personal attendance, section 205 Cr.P.C. When the magistrate, normally an accused person is required to appear before the court on each and every date of hearing. Even the complaint. If they don't appear before the court of law, and at least an application should be made through a lawyer that the personal appearance may be dispensed with. That I mean not required. It's not like a civil case. If you don't come, nothing happens. The lawyer is there. So in a criminal case under section 205, an application is required to be made to a magistrate that my appearance may kindly be dispensed with today or till the hearing, till the framing of a charge. If a sick person cannot come hospitalized, till the framing of a charge, my presence may be dispensed with. That can be done. Okay. Then plea bargain to kal check kar liya humne. I won't repeat section 265A to L. I won't repeat. Yesterday we have seen. Please see yesterday's lecture. Okay. Then accomplice का मतलब check कर लीजिए आप. Accomplice का definition दिया गया है. Accomplice का definition नहीं है. I got a dictionary meaning here. The expression accomplice you'll find under section 306 Cr.P.C. Before that, I'll give you the definition. Accomplice means who intentionally and voluntarily participates with another in the commission of the crime or by failing to prevent it, though under duty to do so. Because under the Cr.P.C. section 38 clearly tells you, you are required to assist the, you are required to inform the court. You cannot take up the plea. Yeah. Section 37 says that the public is required to assist the magistrate and police. And even under the provisions of 41 onwards here, you are required to inform the police. Private person has to inform the police that offender is hiding in so and so place. Otherwise, you will be liable to take it here. Now, the provision with regard to accomplice you will find in section 306. वो 306 में दिखा गया ना, tendering pardon to accomplice. देख लिया आपने? Now in Sheena murder case, the famous murder case, the driver Rai has been declared as an accomplice, isn't it? The accused person who has been implicated, he tells the court, I will assist the police and help the court in ascertaining the, in providing details of the case. So 306 के अंदर a pardon is recorded by the court. 306, right? I'm not, yes. Section 306 of the CRPC, check करें, tender a pardon to accomplice. You will find reference here. Then another reference you will find of accomplice is section, you will find section 30 of the Evidence Act. Under section 30 of the Evidence Act,
So 7.5 minutes are left.
Acha, section 30 of the Evidence Act, where the confession is made by a person, I have committed the offense against myself and others, his confession is binding in a joint trial. If the trial is not joint, it is not. So there is one provision. Then section 114B of the Evidence Act also mentions about the accomplice. It says that an accomplice is unworthy of credit unless he is corroborated in material particular. Please remember this. Then section 133 says of the Evidence Act, section 133 आप check करेंगे, an accomplice shall be competent witness against an accused person, and conviction is not only illegal, but it proceeds upon the uncorroborated testimony of the accomplice. There is a contradiction between section 133 and section 114B. That it is ultimately the discretion of the court whether you require corroboration or not. Corroboration कहाँ पे मिलता है नहीं मिलता है, that will is given under the provisions of the Indian Evidence Act, isn't it? Certain facts needs to be corroborated. Without corroboration, the matter cannot be proved before the court of law. Okay, so these are the evidence. Now, first information तो हमने check कर लिए. Let us not be there. Yesterday we dealt with first information report. Then next is what is an appeal. Appeals are under section 372 to 394. The definition of the appeal again is not given. I will give you what is an appeal. Appeal, it is defined as an application of a plea that is brought to a higher court to set aside the decision of the lower court. It is made to the higher court. That is an appeal. Now, under the CRPC section 372 to 394 deal with appeal. Then F is a child in need of a care and protection. Please, that is section 214 of the JJ Act. That you see, please here. I won't be reading it because there is no time. You just go home and read it carefully. I'm pointing out this section. Then what remedy available to Ajay's parent mentioned in specifically, that is with regard to the problem. That is the problem which is what's it says that maintenance case where the parents have been neglected. Section 125(1)(d). 125(1)(d) the answer, that is Ajay's parents are old people and they have been neglected. Then the next is an offense is committed. The next is an offense is committed for which punishable for 6 months. Within what period the offense should be, complaint should be filed. Now within 1 year, that is section 468(2)(b). Check कर लीजिए. Then the period of limitation commences from which date? Section 469(a), (b) and (c). From the date of the commission of the offense and from the date of the knowledge. Then define probation. In his defined probation, give reason. Section 3 and 4 of the Probation of Offenders Act. वो देख लीजिए आप. Explain the powers of the court to release a person probation. Section 4. Earlier answer is section 3 and second is section 4. Okay. Then distinguish between investigation, trial, and inquiry. That is section 2H में investigation conducted by police officer or any private person with the permission of the magistrate and not the magistrate. Whereas inquiry is conducted by magistrate and not by police officer. Isn't it? Trial mean after the completion of the evidence, after when a charge sheet is filed under 207, the uh, the commencement of the examination proceeding take place before a magistrate or a criminal court by examining witnesses, production document is a trial, though trial is not defined in the act. Then classify the various criminal code and state power of each of the court. So here the various criminal courts we have seen: the court of session, section 6, 7, 8, 9, the court of session, judicial magistrate first class, judicial magistrate second class, metropolitan magistrate, judicial magistrate, executive magistrate. Okay, section 6, 7, 8, 9, 10 are the answers in this regard. Now, anybody has any question, please ask me. I think we have completed this question today. Now, tomorrow's time, I requested OGIS to take a little longer time, if possible. Okay. Once you tell me that you suggest the same time and little longer time you want it. Can we take little 3 sessions instead of having 2 sessions?
Yes, sir. 4 to 6 would be fine.
Yeah, 4 to 6. You want 4 o'clock only? Okay, tomorrow also 4 to 6. Okay, tomorrow will be final because tomorrow we'll concentrate more on the what you call the solution, the problems, the problems which have been raised by the examiners. That is called situational problems. Okay. Otherwise, more or less, you are covered. Anybody has any doubt? Please ask me. Take advantage of the time which is available to you. Nobody has any problem? Nobody has any question? Including Ashish?
No, sir, no questions for now. I'll save some for tomorrow.
Yeah, everything is clear. Today's lecture is clear, no?
Yes, sir. Yes.
Today's lecture is clear. Okay, I'm glad you all have understood it. Okay, all of you, everybody. Okay, thank you so much, and we'll see you tomorrow. Okay, Mansi and Ojas and everybody. All the best.
Thank you, sir.
Thank you, sir.
Thank you. Thank you so much. Tomorrow, 4
Thank
o'clock
you,
to
sir.
6 o'clock. Thank you. Tomorrow will be
Thank
the
you,
last
sir.
lecture, please. Thank you. My pleasure, dear. Enjoy all of you and do well in the exam. Okay, take care.
Have a
See you
nice
tomorrow. Thank you. Good evening.